we need to establish a quorum. So I'm going to have Kristen, if she will please call the roll.
Okay, Dr. Lewis,
Present.
Dr. Hawkins, Dr. Hawkins.
Oh, don't tell me. Oh, good.
Oh, there he is. Okay. Ms. Lubiano.
Shh.
Dr. Tirado.
Present.
Mr. Watkins.
Present.
And Dr. Yip.
Present.
We have a quorum.
Okay, we have a quorum. I have a question for the court reporter. Is the court reporter there? Court reporter. She's there?
Oh, yes, I am, Mr.
Okay.
Lewis, Dr. Lewis.
That's all right. Yeah, you're cutting in and out, but I have a question to ask you. Do you need any of the panel members to state their name for you and spelling, or have you managed to develop your list?
I have developed a list.
Okay, well.
Can you hear me?
Yes, occasionally one of your words drops, but we can hear you. I can hear you.
Okay, and then I'm not sure why I'm not showing up on the video. It says it's disabled. But I'm fine. I can make it.
Okay, that's fine. We can hear you if you have something to say during the proceedings. The next order of business on the agenda is to elect the vice chair, since David Wormuth has now stepped off. So I'm going to ask for nominations for the vice chair.
This is Dr. Hawkins. I'd like to nominate Dr. Felix Yip, if he's willing to serve.
Okay, is there a second on Dr. Yip's nomination?
I'll second that.
Okay, good. We have a motion and a second for Dr. Yip to serve as vice chair of panel A. Any other nominations? Okay, seeing none, nominations are closed. We will now have the elections. So, Kristen, could you please perform a voice vote?
Yes. Dr. Lewis.
Yes, yay.
Dr. Hawkins.
Yes.
Ms. Lubiano.
Aye.
Dr. Tirado.
Yes.
Mr. Watkins.
Yes.
And Dr. Yip.
Yes, thank you.
Okay. Dr. Yip, congratulations. You're the vice chair of panel A. I hope you're up to the task. Okay, let's move on. Because we have the next order of business is to hear oral arguments on non-adopted proposed decision in the case of Dr. Dougal. I would like the judge to introduce herself and proceed with leading the oral arguments. Judge Brown, please take over.
Dr. Lewis and Judge Brown, if you don't mind, if I could go ahead and promote the involved parties so that they can be in speaking position before you actually kick that off. Give me just one moment.
Sean, can I ask you a question? Can you hear me well?
Yes.
Thank you.
Okay. Brenda Reyes, can you please confirm you have audio?
Yes, this is Brenda Reyes.
Okay. Paul Chan, can you please confirm that you're with your client and you have audio? Mr. Chan, you may be muted down at the bottom. There's a little...
Can you hear me now?
Yes, coming through as well. Both of you can enable your video now as well. And,
Can I
sorry
can,
to interject there, but we can
okay.
go ahead and turn it over to Judge Brown.
Okay, I just have to interject one comment, please, Sean. I want to welcome our newest member, Dr. Tirado, to Panel A. So welcome to the team of Panel A.
Thank you.
Dr. Tirado, you're welcome.
Thank you.
I'll second that. That's good.
Yes.
Welcome.
Now, Judge Brown, would you proceed and introduce yourself and proceed with leading the oral arguments?
All right, thank you, Dr. Lewis. Hopefully everybody can hear me okay, and if not, please let me know. My name is Jeanette Brown, and I am your judge this morning. Ms. Lee, Madam Court Reporter, are you set to go?
Yes, I'm ready, Your Honor.
Okay, let's go ahead and get on the record. And I will call the case. All right, we are here this morning before the Medical Board of California. My name is Jeanette Brown, and I'm an administrative law judge with the Office of Administrative Hearings, and I have been assigned to preside over this matter. A quorum has been established prior to us getting on the record, and the members have identified themselves for the record. So at this time, may I take the appearance of the Deputy Attorney General, please?
Good morning, Your Honor. Brenda Reyes, Deputy Attorney General, appearing for the people.
Thank you, and good morning, Ms. Reyes. And may I take the appearance of the petitioner?
Yes, good morning, Your Honor. Good morning, member of the board, Ms. Reyes. My name is Paul Chan. I am an attorney. I represent the petitioner in this matter, Ashwani Dougal, who's present with me. Good morning.
Okay, and good morning to you, Mr. Chan and Mr. Dougal. At this time, should the board be asking questions of Mr. Dougal? I'm going to go ahead and put him under oath just in case. So if he could kindly raise his right hand.
Let me get there.
Okay. Okay. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
Okay, very good. Thank you so much. I appreciate that. Okay, so the parties have already been provided with the protocols for oral argument this morning, so I'm not going to go through the ground rules unless you want me to. So at this time, we've got time limits set for oral argument this morning, and I'll go ahead and state those for the record. We have opening argument first by the respondent, that's 15 minutes. A response by the complainant, another 15 minutes. Closing argument by the respondent for 5 minutes. And then closing argument by complainant, 5 minutes. And I'll put my timer on and let you know when time is almost up. Before we proceed, just to emphasize that the arguments are based on the existing record and no new evidence will be heard. And you may be asked to, point to some specific citation in the record if asked. And everything is proceeding pursuant to California Code of Regulations, Title 16, Sections 1364.30 and 1364.32. All right. With that, any questions before we proceed with the oral argument?
No.
No.
Okay. Thank you both. All right. Opening argument by respondent, Mr. Chan.
Great. Thank you.
You may proceed.
Thank you. Good morning again, everyone. So I don't want to use my time to reiterate what I've already submitted as far as the written arguments. I'm sure each of the members of the board have had an opportunity to review the records, review the transcript, review the written arguments. What I would rather do instead is just to highlight certain points that I think is important in guiding the board's decision. first of all, as the board is well aware, disciplinary actions shall be calculated to aid in the rehabilitation of a licensee. And what that basically means is that each condition should serve a specific purpose. It's not to add a burden, it's not to be punitive, but it should aid in the specific purpose of aiding in the rehabilitation and for protection of the public. Now, in this case, as the board is well aware, there was a full evidentiary hearing. Evidence was presented, the administrative law judge heard the evidence and drafted a proposed decision that based on the evidence presented, the judge felt that the conditions imposed were necessary and proper in aiding the rehabilitation and also in protection of the public. Now, the board's focus in this case is, in non-adopting the decision, is should additional conditions be imposed? And that's a good question. My client will accept and concede that monitor practice for a period of 1 year would not be unreasonable, and it would aid in his rehabilitation. And I believe this was something that the people had recommended and suggested as well, that he practice monitor for a period of 1 year. Now, the two issues that was raised for the first time is the issue of ethics examination and the special purpose examination. Now, I will note that from the record and the transcript of the hearing, this issue was never raised by the people. The people's focus in the entire case, including the closing argument of the actual hearing, was focused primarily on Mr. Dougal's past alcohol use and consumption and whether or not he's shown sufficient rehabilitation in that regard. In fact, that was the point of the people's argument, was to ask for the additional conditions under the model disciplinary guidelines for the optional condition of testing for alcohol use and rehabilitation. And as part of that, the administrative law judge who heard the case imposed those conditions. My client's ethics was never an issue in this case, never raised by the people, never challenged. But to address that, I will also note that as part of the evidence submitted, my client submitted extensive evidence which was accepted of continuing medical education in professional boundaries and sexual harassment compliance. And it's also important to note that the issue which gave rise to the discipline occurred in 2009 that resulted in a criminal conviction in Indiana. My client has done everything required to the extent where the conviction has been set aside and dismissed. Now, the second issue raised is this issue of the special purpose examination, because there's an argument that somehow my client is not competent or needs to demonstrate competency to practice medicine safely. Once again, that issue was also not raised during the actual hearing. So to raise it now after the hearing in the form of a written argument is really not fair to my client. It's a due process issue, because had that issue been raised at the hearing, we would have adequately addressed it. But more importantly, my client's competency to practice medicine safely in 2021, based on the evidence, was also addressed that he is competent, that he can practice safely. That was addressed in the judge's proposed decision. That was submitted in the evidence of the extensive CMEs that my client has submitted. It's submitted in the form of his own testimony, unchallenged, unrebutted. It is evidence. The hearing judge accepted it. My client this is not a situation where my client ceased practice for some period of time and is now seeking reinstatement. He's been practicing. He's been practicing per the evidence in Indiana and in India. That's never been an issue. A real brief point that I do want to note, on page 2, line 25 of the People's Written Argument, it's alleged and stated that my client's Indiana license is on indefinite suspension. That is incorrect. My client's Indiana license was never on an indefinite suspension. It is on indefinite probation. Okay, and that's indicated by the record and the evidence. There's certain additional conditions he needs to require before Indiana will lift it. And him being in California obviously makes that difficult at this time. That is something I want to point out to the board. It's important that we give a significant amount of weight to each actual trier of fact, who had the opportunity to observe my client's testimony and review all of the evidence. And in that process, the proposed decision came with conditions that the hearing judge felt was adequate and suitable to rehabilitate and to protect the public. So I want to end this, and also my client is here and he welcomes any specific questions that any members of this panel may have for me or for him. And he's happy to answer those questions directly, as he always has throughout this case. But I'll reserve any additional statements as part of my closing after hearing any arguments from the people. But to summarize, a practice monitor for 1 year is not being disputed. And I want to also just reiterate, the practice monitor would have an obligation and duty to raise any issues of deficiencies in competency or in practice to the board if they felt that my client is not able to practice safely at that time. That's the purpose of a practice monitor. It is that additional layer of protection of the public. So with that, I will end. And like I said, my additional time, if any members of the board wish to directly ask me questions or my client's questions, we welcome that. Thank you.
All right, thank you, Mr. Chan. Are there any questions from the board at this time, or we can go dive right into the response by the complainant?
I have a question, Dr. Hawkins. May I proceed?
You may.
I guess the judge will tell me if this is an out-of-bound question. So I had the opportunity to review Dr. Dougal's chart, and my question to him is, I wonder whether you would make any changes, if you have it, to your narrative summary when you ask for reinstatement of your license signed October 24, 2018, when your narrative statement talks about why you wanted to be reinstated. And I just wondered, since it was done in October 2018, if the judge can allow it, whether you would make any changes to that narrative statement about why you wanted your license reinstated.
All right, so that would be adding additional evidence to the narrative. And since we are restricted to the existing record, I believe Mr. Dougal will not be able to answer that question.
Okay, I wonder whether that was true. Okay, thank you, Judge.
You're welcome. Any other questions? Okay, so let's go ahead and move on to the responsive argument.
I have a question. One quick question. Where is Dr. Dougal currently practicing, or plans to practice? Because I'm hearing India and California. Where's the primary location? That must be in the record.
So presently I am working as a consultant pathologist and doing clinical training in Indiana. and during my visits to India. And that is during my visits to India and Indiana. I'm not practicing at all in California.
Okay, so no clinical practice, more teaching and of residents and in their training, but you don't have hands-on experience. Is that correct?
No, I have already done multiple CMEs online. I've done a clinical pathologic training at Bal Memorial Hospital, Muncie, Indiana.
Guys, this is the court reporter. I'm having difficulty hearing the witness. Could I have him slow down and speak louder and enunciate the kind of the big words, I guess, or medical words?
Sir and madam, as my CV states, during my frequent visits to Indiana, I've been practicing pathology and also doing clinical training under the supervision of the physician. Besides that, I am doing CME online in California, and to continue my clinical skills, I am going through the educational slides using the microscope at my home in California. In other words, pathology and clinical training in India and Indiana, and CME and practical education training and self training and using my microscope in histopathology.
Thank you.
I'm sorry, Dr. Hawkins, may I ask another quick question? I apologize. May I speak?
You may.
Yes.
And so, although I understand the question about alcohol use, my question relates to another part of the reason for the discipline. And so my question, Dr. Dougal, is whether you have resumed or continued to pay financial restitution to the victim in your civil case.
Yes, I paid $5,000 many years back, and then I have a settlement between the attorney or the collection agency attorney of the victim that I'm going to pay in installments, which is at least $5,000 a year, starting my work in California.
That was acceptable to them, I guess.
Yes.
I have a question.
Thank you.
I have a question.
Please
Go ahead. Yeah, go ahead.
This is a question. Good morning, Mr. Dougal, Dr. Dougal. This question is pertain to that same thing. So what I'm hearing you say is that you've paid $5,000 some years back. But as per the record, that was in 2011, and you make paying the victim in the circumstances condition upon you working in California. Is that correct?
No, that's not exactly correct, but that's a settlement. As I start working and earning, I am intent to pay in installments, and this was agreed by their attorney.
So an intention to pay does not really constitute paying, right?
Yes, in the past years, because of the financial burden, I could not pay, but my intentions are clear to pay in installments, and the settlement was done, and I am going to pay the interest on the balance also.
So my next question is to do with the rehabilitation that you speak of. Would you consider that paying the settlement as part of the rehabilitation process because it all relates to that incident in 2009?
Yes, sir.
So this rehabilitation process, from your point of view, is actually not complete. Would you agree with that?
Rehabilitation as far as alcohol use and another CME on my convictions is already done. The only part was the financial thing, because in the last years, and as you understand, I have gone through the process in India, having psychological financial burden on me about taking care of my medical licenses and multiple things. So I was really under the financial burden. I borrowed the money and have a settlement with my wife to pay it as soon as I start working.
So my second last question, still under the rehabilitation banner, in 2016 you had a relapse, and you had a conversation with a psychologist about it, or your psychiatrist. I don't know, Dr. Mente or something.
Yes, sir.
And in that, the record explains it, but I just want to hear from you. How did the doctor misunderstand you as per that event where you were actually charged, convicted for public intoxication, but you did not tell that to the doctor at the time. So the doctor made a statement based on stuff that you told her.
Okay. Sir, I recollect everything. I was arrested when I was sleeping in the car. And when I met Dr. Mantani, before that, I already met my attorney, Mr. Simone. And he said, while you were sleeping in the car for 3-4 hours, there won't be anything. I have not seen the DUI charges which was shown to me during the hearing. That was the first time I saw the DUI hearing. When I met Dr. Mantani, I mentioned about my relapse. And I said there was no wrongdoing, which I meant that I was just sleeping. There was no misbehavior in the public. And I thought that I was arrested just because of when I will be sober, I will be released, and ultimately I pleaded guilty on public intoxication. But when I met Dr. Mantani, it was in my mind there was no DUI charges, and I did not do anything misbehavior that was wrongdoing. But in detail, I told the incidents. I never saw the DUI charges report which was submitted to my attorney.
And my final question is, what is your sobriety date? The date that you decided you were going to stop drinking?
I stopped drinking after my January 2016 incidents. That is
So you don't have a specific date.
It was, I think it was 16th January 2016 when I was arrested. And
Thank you for your...
I haven't, that is my story.
Thank you.
All right, thank you, Mr. Watkins. Any other questions?
I have one question, Lori here,
All right.
if I might ask.
You may.
Thank you. I saw in the record, Dr. Dougal, that you identified stress as the trigger for your incidents, and understanding that stress is part of our life. I'd like to know how you manage it or manage it differently since the incidents.
Yes, as I already quoted that I was lonely, was in the transition phase of moving to California. I was stressed out and had blackout. I accepted the responsibility. After moving to California with my wife, with all my support from my wife, my family, friends, the stress has almost gone from, on the scale of 10 to 2. Now I am good with the family. My family is supportive. I do work in Indiana, getting at home at busy. So in other words, the stress was because of loneliness and has been taken care. And after going with the AA classes, counseling, which really has helped me. And above all is the self-determination. And I don't want to move my life with that stigma. I want to show to the society and my near and dear ones to be a honest, sober, and ethical professional man.
Thank you. And just one other question. I also saw on the record that with part of your AA therapy, you were looking for a sponsor. And I was curious if you are continuing that therapy and if you found that sponsor.
No, I still am continuing AA meetings, which is required by the Indiana Medical Board. I lost my sponsor sometime in 2019. I came back from India in January 2020. I again contacted the sponsor recently, and Vico Garcia is again my sponsor. And right now I'm taking 8 video AA meetings and are submitting to Indiana Medical Board, which is a requirement of my probation of Indiana medical license.
Thank you. No further questions.
All right, thank you, Ms. Lubiano. If no further questions, we'll move on to the responsive argument by the complainant. Ms. Reyes, you may proceed.
Thank you, Your Honor. Good morning, board members. First of all, I would like to correct a misstatement in the people's argument. And if I may direct you at pages 5 to 6, the bottom of 5, top of 6 at the people's argument, during a discussion of the evidence with regard to Mr. Dougal's work in India. It stated that there was no proof offered at the hearing of his practice in India, and there was no reference letter submitted by any practitioner to attest his practice. I would like to, in fact, correct that. Petitioner did offer exhibits, at Exhibit D, pages 6 and 7. There are 2 letters there from a Dr. Parveen, P-A-R-V-E-E-N, last name Serene, and the 2 different letters have 2 different spellings of his last name. One is S-A-R-I-N, the second is S-A-R-E-E-N. And these 2 letters were from Dr. Serene, who is in India, who attests to Mr. Dougal doing some pathology work and clinical training work with him. I would note, however, that there is a significant reliability issue. The declarations are not under penalty of perjury. As I've indicated, there's 2 different spellings of the last name. And in any event, the declarations provide little detail of the nature of the work or the quality of the work. But they were offered and admitted as administrative hearsay to corroborate Mr. Dougal's testimony that he worked with Dr. Serene, shadowing him and getting some clinical experience. And this was addressed at page 78, lines 1 through 6 of the transcript of the hearing. So in any event, that evidence does not change the people's position with regard to the need for a clinical competency exam, because essentially we have Dr. Dougal's statements that he has engaged in pathology practice, essentially shadowing or being supervised by practitioners in India, and then also Dr. Reddy in Indiana. But I would submit that the evidence, this medical board here in California must have confidence in Dr. Dougal's competency to practice. And I don't believe that there's sufficient evidence in this record to really establish the quality of his work, the true nature and details of his work. I understand there is some pathology practice that has been done, but nevertheless, this board has to have confidence both to assure itself that he's competent to practice, but more importantly, for protection of the public. And I believe it is not a burdensome requirement to have him submit to a competency examination in order to provide that assurance, and also to give some to a basic standard in terms of where he's at for the practice monitor as well, if the board were to impose such a condition. And I would submit that contrary to counsel's argument here that the CME is sufficient to establish that, I would argue, no, it's not. What it establishes is that Dr. Dougal may in fact be maintaining his currency with regard to changes in the practice of pathology, but that is not sufficient in and of itself to demonstrate his competency to actually return to practice. And so I would stand by the recommendation that he be required to submit to a competency examination to establish that current competency. In addition, I believe that a professionalism course, an ethics course, is an appropriate recommendation under the nature of this case in order for, again, this board to be satisfied that Mr. Dougal does in fact understand the boundary issues and that the nature of his conduct under this board's disciplinary guidelines would require him to complete an ethics course for the satisfaction of this board. And further, I believe he must have a practice monitor if this board returns him to practice. And when I say the people have recommended 1 year. What I would be clear on that, though, given that oftentimes it takes time to get to identify a practitioner, Dr. Dougal also needs to find a practice. I would ask this board to ensure if such a recommendation is adopted and included in any decision, that it must expressly provide that it not be for the first year of probation, but that at least a full year of monitoring occur, because it may well be that the monitor doesn't begin until sometime down the road on the probationary term. And so I would recommend that the monitoring occur for at least a year, not that it be for the first year, because we all know that sometimes those things don't start for a while. I would also like to address a couple of points by counsel. The people are not required to set forth all the recommendations. Counsel has argued that this was not raised at the hearing and that therefore it's a burden and it's unfair. Well, that's not the requirement for making recommendations about appropriate discipline. The discipline arises from the evidence in the record and the burden is on petitioner to establish that he's competent and that he's been rehabilitated and that he can in fact return to practice. And therefore the recommendations made by the people in this case arise from the evidence submitted on this record. Whether or not they were the recommendations of what should be appropriate discipline was offered, that's not a requirement. This is based on what the evidence is in the record as to whether or not Mr. Dougal has adequately established that he is competent to return to practice at this time. And this board obviously must identify what those appropriate terms would be for the protection of the public. And therefore, that's the basis of the recommendations in this matter, that Mr. Dougal be required to complete a professionalism program, an ethics course, that he be required to submit to a written examination, such as the SPECS examination or an equivalent, and that he have a practice monitor for a period of time while he returns to practice. With regard to the evidence on the substance abuse, the alcohol abuse issue, I believe that the recommendation of the administrative law judge that Mr. Dougal submit to a psychiatric examination, that he submit to psychotherapy, I believe those terms will adequately protect the public and provide this board with information that would indicate whether or not any additional terms are required with regard to the substance abuse issue. In my experience with these cases, I believe the evaluation based on the evidence in this case, the evaluator obviously should be someone with an addiction medicine background, and under circumstances, the evaluator should be able to provide this board with any insight or further recommendations with regard to the substance abuse issue that has been revealed in the case. And therefore, the people have made the 3 recommendations with regard to additional terms, but I think otherwise, I believe the proposed decision sets forth sufficient terms that will protect the public. The biological fluid testing obviously will give the board immediate information with regard to any violation on with regard to drinking. I would submit it on that, and I am happy to answer any questions that the board members may have.
I have a question that is partly directed to Mr. Dougal and to this process. In this case, we are driving it towards the alcohol abuse that has taken place and Dr. Dougal's alcohol use disorder, right? But his conviction in 2009 was for sexual battery and criminal confinement. And even though the alcohol played a role in it, I'm asking, how do we take that in consideration in making this part of the order and part of our decision? Because from what it sounds like, from what I'm hearing, is that it is all about the alcohol use disorder. And the record shows that he has had 2 relapses in 2011 and in 2016. The ALJ proposed a period of 4 years, and there's 5-year intervals in his relapses. And then some of the issues that I'm concerned about is we are not speaking about the victim in this case that has not received restitution. So I'm just would like to have more of a clarification about what gets included and what gets excluded from the people's case.
Well, with regard to the sexual battery, the 2009 conviction, the evidence in this case demonstrated that there is certificates of continuing medical education that address boundary issues, but obviously this was not a patient that we're referring to. I believe what the evidence established in this case is that it was an isolated incident. It involved an individual that he knew that was employed in his home for many years. I believe he testified at least 7 years this woman had worked in his home. And he suffered the conviction. He was required to register as a sexual offender. And obviously that was the basis for the revocation of his license. Sufficient time passed. There is evidence in the record that he no longer is required to register as a sexual offender. And therefore, I believe the evidence has addressed that issue with regard to the conduct that occurred. I don't believe that there's any evidence that would cause concern of a repeat of that type of misconduct, given the nature of given the circumstances under which the event occurred and the passage of time. It appears to me that the significant issue that's ongoing is really related to the substance abuse, the alcohol abuse, and the last event we have in this case was in 2016. There's evidence in the record that he has done some biological fluid testing, that he is going to AA, that he was required by the criminal courts to complete alcohol treatment programs or coursework and therapy. The one remaining issue, I agree with you, is, Mr. Watkins, is the issue of the restitution to the victim. We have nothing to dispute Mr. Dougal's statements with regard to this, and I think the evidence supports he's not been working, that he did not have the resources to pay the victim. And the evidence in the record is that the matter has been sent to a collection agency, and he's reached some agreement to pay this restitution when he is employed. Now, the question, I don't know that I can answer this, whether or not this board wishes to get involved in that process of monitoring the restitution in another state. I can't really address that, and I don't know that this board wants to get into the practice of monitoring that kind of responsibility that's actually occurring in another state. But I don't disagree that that remains a pending issue, but I think the circumstances as set forth in the record explain the failure to pay, which is Mr. Dougal has had no resources with which to pay that restitution, but he has, under oath on the record, stated a full intent to do that and an agreement with the collection agency, with the attorney for the victim, that that would occur when he resumes employment. And I believe that's where it stands in this matter.
Can I just clarify something? As was mentioned, you mentioned that his housekeeper was not a patient. So that's a differentiating point, right? And yet, that is the housekeeper also represents the public, and it is clear that public harm has occurred. I'm just wanting to be diligent enough to ask the question of, if we make a distinction that a patient wasn't hurt, so it's not in the workplace, but the propensity to act in a violent and sexual manner was present. It wasn't present before 2009, and it seems not to be present now. And I couldn't find within the record the combination of factors outside of what Mr. Dougal has said in testimony about what that is, what gave rise to it.
I believe the record does offer some evidence on that. What the record shows, and I believe Mr. Dougal testified to, is that the family made a decision to move from Indiana to California. Mr. Dougal's wife left first and took the family, the children or the child, with her. Mr. Dougal was left in Indiana on his own while he tried to obtain employment in California. And he testified he was lonely. He became bitter and resentful towards his wife, who had begun a practice in California. He was lonely. He testified to being stressed out, I think being on his own. So I am no way suggesting that these are legitimate factors for the conduct. This was the explanation offered. He has testified that what occurred with his housekeeper was after a night of drinking when he blacked out, that he was still under the effects in the morning, that there was perhaps miscommunication with the victim. And then we have the tales of what the victim alleged, that he inappropriately touched her and confined her to the room and all that. So I agree with you, but I would offer that there is no any other evidence in the record to establish any propensity for this conduct. There's no evidence of any further inappropriate touching or physical misconduct with another victim. And so I believe what the record establishes, under the circumstances that Mr. Dougal was under at the time of the events, this was an isolated incident back in, I think it's 2009 it might have occurred, or that's when the conviction was. But we don't have any evidence of any propensity or reoccurrence of that, or behavior of that nature. So I don't know that we have evidence to warrant any term with regard to that type of misconduct. And I believe the issue has become more addressing the alcohol abuse that has occurred, that the record has established since the conviction itself, the conviction for the sexual battery. I'm not sure, does that answer your question?
I'm okay. Thank you. That's fine.
Yeah.
Yeah.
Dr. Hawkins, may I ask a question?
Please proceed.
Okay. Thank you, Attorney Reyes. So I understand the request for competency and practice monitor. And so my question and comment has to do with the latter. So it's very common, depending on the setting of pathologists, for them to have someone who, it's very common, you have a pathologist who's assigned to the case, they look at a slide and they say, there's this diagnosis. It's very common for there to be a second pathologist to look at the same slide and say, yes, I agree or I disagree. And so my question is, so if you're a consultant not in that sitting, you may be the only pathologist looking at a slide. But my question is, do we have to ask in the setting of practice monitoring, in the setting of pathologists, that a distinction is made between a colleague whose job it is to look at the same slide and say, yes, I agree or disagree, versus having someone totally independent monitoring the diagnosis, the evaluation by Dr. Dougal. And I mention that just because pathology is a little bit different in that way. Do you understand my question?
Are you asking me?
Yeah, I'm speaking to you. Yes, I'm speaking to you.
Yes, thank you. Pardon me. I have to acknowledge here that I am not a doctor. So I cannot judge. I don't feel qualified to really address the quality of review or the nature of the relationship. I know the board's disciplinary guidelines set forth parameters for a practice monitor in terms of the relationship with the party they're monitoring. But in terms of the quality or nature of the review, I don't feel really qualified as a lawyer to address, in terms of medical practice, the appropriate nature of the or quality of the monitoring that should occur. And I would really defer to the board's expertise in that regard.
Well, thank you very much. And so in closed session, we'll talk about the appropriateness of this. And thank you very much.
Yes, Ms. Reyes, you're correct. And no disrespect, but I agree with Dr. Hawkins is that not all monitors fit into a certain category. It's like a square peg in a round hole. We think of practice monitors as somebody sort of present around reviewing charts. And what Dr. Hawkins says is in a clinical pathology setting, that's built in, a second look. So I would preferably defer to the board's monitoring to come up with what works in that practice setting. And the board is able to do that. That's all I have to say.
If I may, my recommendation in that regard, whatever that nature of monitoring is, my recommendation, the people's recommendation in this case, is for purposes of ensuring that he has transitioned to and returned to independent practice, that he is competent in what he's doing, that he is establishing himself appropriately. So it seems to me that some nature of feedback would be appropriate to the board in terms of how Mr. Dougal is getting off the ground, how he's establishing himself, the nature of his work, whether or not he's practicing consistent with the standard of care. And it may well be that it's that second reviewer which is providing that feedback that's in the setting, and perhaps that might be the easiest way to do that. And
I agree.
Taylor.
Yes, thank you. Yes.
Dr. Yip, I was going to say until the closing, but just for FYI for non-physician, not all pathology has second look immediately by analysis pathology. So the practice monitor, not just the quality of the reading, but also whether the pathology show on time, respond on time, conduct work ethics around the environment. So this is the job of the practice monitor, which again also under the purview of the enforcement and the probation officer to monitor that. So it's just not a second reading. Thank you.
Very good. Yes. Well, you know how the system works, so I appreciate that. Yeah, it's another level that the enforcement group can look at and craft their own monitoring program. So.
All right. Any other questions before we move on to closing argument? Hearing none, then Mr. Chan, closing.
Yes, just real briefly. Once again, thank you for everyone's time. I think the petitioner met his burden of proving sufficient rehabilitation. I think the conditions of probation, as delineated by the hearing judge at the hearing, is sufficient. I have no objections, my client have no objections to the imposition of a practice monitor. As evidenced by some of the statements from various board members today, that is necessary. And obviously the practice monitor adds that additional layer, as Dr. Yip talked about. It's not just his competency, but overall his demeanor, how he interacts with individuals. And it's that ears and eyes to the probation department. With that said, I think my client submitted sufficient evidence of his rehabilitation that he is safe to return to practice under the conditions proposed by the administrative law judge. The additional condition of a practice monitor for 1 year, once he obtains one, I think that's reasonable. I will submit on my previous arguments that based on the evidence and also based on what my client has already done, an ethics course along with the special purpose examination is not necessary. This is not a case where we're talking about someone who has been out of practice. He's actually been actively practicing, in India and Indiana. It's also important to note that the Indiana board imposed conditions on Dr. Dougal as far as what they required of him. And, we respect the Medical Board of California, we respect other boards, states, their decision, right? That's why we discipline individuals if they're disciplined in a different state. In that same thought process, we also have to trust that, the fact that Indiana Medical Board placed him on probation and had him comply with their rules and regulations, some deference should be given to that as well. If the Indiana Medical Board felt it was necessary for him to do professionalism courses, professional boundaries courses, that they thought aided in his rehabilitation, some deference should be given to that board as well. For this board, in formulating the appropriate conditions and terms for Dr. Dougal to return to practice in California. Thank you all very much.
Thank you, Mr. Chan. Ms. Reyes, closing argument?
Yes, just very briefly, Your Honor. Obviously, this board's primary responsibility is protection of the public. And I believe the evidence has established that Dr. Dougal may be ready or is in fact ready to return to practice. But I think that there are insufficient terms in the proposed decision at this point to ensure that protection. And I appreciate that there's no disagreement about the need for a practice monitor. And I would hope that this board would impose such a condition for an appropriate term. However, under the circumstances of this case, this board is not required to accept the discipline of another state. Obviously, this board operates independently and guides the practice of medicine here in the state of California. And given the nature of the wrongdoing in this case, I absolutely believe a professionalism course is appropriate under the circumstances of this case, but also to establish current competency. Because what Dr. Dougal has really testified to in the record is that he has been working under the supervision and doing kind of clinical training with other individuals. But I think this board has to have confidence in his ability to practice, his competency to practice if a license is going to be returned. And so under those circumstances, I think it's absolutely appropriate that a written examination be required in order to establish that competency. I don't believe that's an onerous or terribly burdensome responsibility. And I believe it's a basis and basic information that this board should have in order to ensure itself and protect the public that Dr. Dougal is prepared and can practice consistent with the standard of practice in this state. And I would submit on that.
All right, thank you, Reyes.
Judge, Dr. Hawkins, and I apologize. Is it possible to ask one last question to Attorney Reyes?
You bet.
So, Attorney Reyes, do we actually know what type of work Dr. Dougal has been doing in Indiana? I mean, and this speaks to this idea about competency. We were told that, he's been practicing. We're not sure what we can do about the information from India, but do we know what he's actually been doing in Indiana in terms of the practice of pathology?
My recollection from the record is two different things. One is he's done work with the National Autopsy Services. So he has been doing pathology work with that group, and there is a letter included in the record as well. He has also testified his work with Dr. Reddy in Indiana there is some, he's doing, best recollection is he testified that he's doing physical examinations and doing kind of clinical training with them, but he's not engaged in a clinical practice. That's not really his background. And to the extent he's doing, pathology practice with Dr. Reddy, Dr. Reddy's expertise is he's I think he's a surgeon. He specializes in internal medicine and cardiology. So I raised the question as to whether or not that level of supervision, that was one of my concerns here, and that's the reason for the recommendation for the examination is Dr. Reddy is not a pathologist, so we don't really have evidence of the detail of his supervision, but he's not been engaged in any kind of clinical practice formally because he's not approved for that. So he's really testified that he's shadowing these practitioners. And so the details of the work are not entirely, we do know it's pathology, but because it's not fully fleshed out, perhaps that's the reason for the recommendation on the examination as well.
Thank you. Thank you.
All right, Mr. Chan, you want to add anything to that?
No.
Okay, very good. With that then, there being no further questions, that concludes the petition oral arguments in this matter. At this time, the record is closed, the case is submitted, and we are off the record.
Thank you.
Thank you all.
So we'll wait a few minutes for the people to sign off. I guess, Sean, you're doing that. We'll wait about 2 or 3 minutes. Sean, 2 or 3 minutes?
Yeah, give me just a few minutes to
it's fine.
expel everyone from the meeting, and I'll let you know when we are in a closed session state. So.
May I interrupt briefly?
Yes, Madam Court Reporter.
Yes, I have 37 pages.
37, great. And time is, I got 10:07.
Yes.
Okay, very good. Thank you, Ms. Leeds.
Thank you, everyone.